I want to ask the question whether the courts of this state delve into a bill or ultimately a law's legislative findings and declarations. Quite a few number of bills these days in each year of the California legislature contain a section, usually a section one of the bill, that contains legislative findings and declarations. And these are basically written expressions of legislative intent, generally meant to, set the stage for the statutory provisions that will follow these findings and declarations, and hopefully to give guidance to both the executive branch that will implement or enforce the statute, as well as the judicial branch that might be called upon to interpret the provisions of the bill or the new law in this case. Um, for example, there's pending litigation challenging the legislature's enactment of a bill, AB 290, in 2019. It was Chapter 862, and it deals with healthcare service plans and health insurance, as well as third-party payments. And a written decision was issued by the U.S. District Court judge for the Central District of California, dated December 30th of 2019. This is Jane Doe versus Javier Becerra. And in section one of AB 290, it contained 10 separate legislative findings and declarations. And in this federal lawsuit, it was a challenge to the validity of the state statute. And the plaintiffs in the case claim violations of federal law, including freedom of association, freedom of speech, federal preemption, contract clause violation, due process, takings, and all these claims. The federal court judge, the district court judge, the trial court judge said, the California legislature found, consistent with mounting nationwide concern, that both AKF and dialysis providers shared an incentive to steer patients into private insurance plans, which could no longer reject patients solely because of their pre-existing ESRD, thereby securing higher reimbursement payouts for providers. And the legislature further identified several what it deemed deleterious consequences that could result from this alleged steering, such as the unjust enrichment of providers and higher out-of-pocket costs to the patients and other things. Again, these findings were contained in section one of the bill, which is standard. So in defending the validity of AB 290, the state, the attorney general, pointed to the legislature's findings and declarations in AB 290. And the state specifically argued that the legislature had identified a compelling interest to support the steering ban. However, the federal district court judge reviewed the findings and said several of the legislature's findings are just the sort of speculative harms that the Supreme Court has ruled to be insufficient. And the judge cited some examples out of there and basically said that the hypothetical phrasing calls into question whether these recited harms are actually real. And the state doesn't dispute the fact that the state has yet to identify a single California patient who was steered into a private insurance plan by a dialysis provider or some sort of third-party payer. So in other words, the federal district judge, the trial court judge in this case, actually looked behind the legislature's statement of findings and declarations and determined that the state has not demonstrated that the harm it recites are real, and the supposed harms are too speculative and conjectural to sustain the state's burden, even under an intermediate level of scrutiny. So one takeaway from this district court opinion is that at least federal judges can and do look beyond the legislative findings and declarations that are found in a bill to determine whether there's a factual basis for these statements. So if the legislature wants to ensure that the courts will utilize these statements to interpret a statute as the legislative branch of state government intends, then hopefully they have a definite factual basis for the statements found in these legislative findings and declarations.